Good morning all. Welcome to the fifth of the 11 Z's with Devereux talks, in which I and Anna Greenley will be talking about unallowable purpose. It's very pleasing to see people returning in such numbers, and thank you also for taking the time to provide feedback on the previous sessions. This talk itself was one that came about as a result of a suggestion given after one of the earlier sessions. And in response to another point raised in the feedback, we'll be circulating after the webinar a list of the cases that are referred to and the citations to save you having to keep a note of those. We're also both going to be using a few slides, and we'll circulate those with the same email. So again, if you do have a chance, please take a couple of minutes at the end to complete the feedback. Some brief practical points for anybody who's new to the 11 Z's or to Zoom webinars as a whole. Whilst you won't be able to speak or turn your camera on, we do encourage you to participate in the webinar through the Q&A. Towards the bottom of your screen, you should see that there is both a chat and a Q&A function. If you have any questions as we go through the session, please put them into the Q&A rather than the chat. We'll then aim to address them at the end of the session, assuming time permits. Myself and Anna won't be monitoring the chat as closely, but I'm sure that the other Devereux barristers who are attending as panelists would be happy to interact with you. So please feel free to put other comments or general criticisms in the chat as we go along. And then finally, as regards parish announcements, yesterday saw the first of a two-part webinar providing an introduction to FTT practice and procedure, delivered by and aimed at more junior practitioners. If there's anyone in your firm that you would be interested in attending the second part, which is next Wednesday, please do write to the Devereux events email address and register for that. Briefly to introduce Anna, she joined Devereux as a tenant last year following completion of her pupillage, and an impressive career which has spanned Deloitte, hedge fund regulation and the public sector. She saw a lot of tax litigation and advisory work during her pupillage and now accepts instructions in tax, including working with me on an unallowable purpose case. So I'm going to speak first on some of the common legal issues that arise on unallowable purpose tests. Anna's then going to speak on some of the more practical issues that arise, for example, deploying evidence, and she's going to take a look at the recent case law for guidance on the factors that have swayed the FTT one way or another in unallowable purpose cases. So as you know, unallowable purpose tests appear throughout the tax code. At the time of HMRC's 2009 consultation, entitled Simplifying Unallowable Purpose Tests, I understand it was estimated that there were 300 different statutory provisions. I'm afraid that anyone hoping for a comprehensive analysis of all such tests in the next 35 minutes is going to be sorely disappointed. What I will focus on are the three legal questions. The first is the subjective versus objective approach to unallowable purpose tests. The second, what is meant by a main purpose. And thirdly, a section that I've entitled, Whose Intention Is It Anyway? So they were introduced unallowable purpose tests in the 1960s, and they've since proliferated in order to target what is seen as abusive tax avoidance. In the 2009 consultation and draft guidance that I mentioned, HMRC set out its view that the tax system should not disrupt or distort normal commercial activities, but should catch transactions which go beyond normal commercial behaviour. And that is the essence of these tests, that they're seeking to define and identify those transactions which are normal commercial transactions, and those which are seen to be driven by or structured in order to achieve a tax motive. I'm not going to look at whether a tax advantage has arisen, which is obviously an issue that has come up in a number of recent cases, but rather on the assumption that there is a tax advantage. I'll consider when it can be said that seeking that advantage from carrying out a transaction or using a structure stops being incidental to the commercial objective and starts being, in its own right, a tax avoidance purpose. So turning to the first of my topics, subjective versus objective. The starting point for considering unallowable purpose tests is often the House of Lords judgment in ILC and Bremner, which considered the purpose test in section 28 of FA 1960 concerning a transaction or transactions in securities. you should there see the text of section 28. In order to avoid the application of the section, a taxpayer had to show that the transactions were carried out either for bona fide commercial reasons or in the ordinary course of making or managing investments, and that none of the transactions had as their main object or one of their main objects to enable tax advantages to be obtained. Lord Pearce said of that test, the object which has to be considered is a subjective matter of intention. It cannot be narrowed down to a mere object of a company divorced from the directors who govern its policy, or the shareholders who are concerned in and vote in favour of the resolutions. So you focus on the humans making the decisions. It is the subjective intention of those in control which counts. The case also distinguished the object of the transaction from its effect. Lord Upjohn said that you cannot necessarily draw from the fact that the taxpayer chose one of two routes which resulted in less tax being paid, the inference that in adopting that course, one of the objects was avoidance of tax. Whether it's appropriate to draw that inference will depend upon the facts of each case, a point that Anna will return to. Ultimately, whether the taxpayer had the requisite purpose is a question of fact for the FTT, which is hard to disturb on appeal. Getting the findings of fact that you want at the FTT is therefore crucial. Many unallowable purpose tests follow the same structure or similar structure to that in section 28 of the FA 1960 and have similarly been found to encompass a subjective test. So for example, recently in the Upper Tribunal decision in Fisher, the Upper Tribunal recorded the agreement of the parties that the motive defence in section 741 of ICTA 1988 in the context of transfer of assets abroad was a subjective test. Of course, it's important to recognise that the fact that it is a subjective test certainly does not mean that the evidence of the relevant witness as to his or her purpose or the purpose of a board of directors is conclusive proof of that intent. Again, this is another point that Anna will return to, but I would liken it to determining someone's intention for the purpose of her domicile. The propositus can lead evidence as to her intention to remain in a place for the rest of her life, but that will fall to be tested against the surrounding circumstances, rather than being accepted at face value. And what is said in the contemporaneous documents is often to be preferred to what is said in a witness statement years after the event in the context of litigation. The subjective nature of the test set out in Brebner and talked about in the TOA provisions contrasts with the test in, for example, section 74ZA of the Income Tax Act. So I'll just bring up the relevant provision there. You can see that that section applies to arrangements, the main purpose, or one of the main purposes of which, is the obtaining of a reduction in tax liability by means of sideways relief or capital gains relief. To similar effect, and I'm sure there are many other examples, you have section 16A in the TCGA, which asks whether the main purpose, or one of the main purposes of the arrangements is to secure a tax advantage. So the statutory tests don't ask what the purpose was of the party that entered into the transaction. In both those examples, it asks what was the purpose of the arrangements. In the case of 7 individuals, Mr. Justice Newey rejected the submission of the taxpayer, based on Brebner, that one finds a purpose of the arrangements entered into by looking at the subjective purpose of the taxpayer who entered into them. Instead, he accepted HMRC's submissions that arrangements themselves could have a purpose theoretically separate from the purpose of the particular taxpayer who has entered into them. And that has particular application, as Mr. Justice Newey recognised, to marketed schemes, where the design of complex arrangements did not involve the particular taxpayer in any way. In those circumstances, you can consider the purpose of those who design the arrangements in a particular way, and the way in which they are promoted to potential participants. So a much more objective test and wide-ranging test. So the non-privileged advice given, marketing materials, template IFA letters, etc., all become particularly important. It's important to note that although this passage in the judgment was fully reasoned, it was technically no obiter, because Mr. Justice Nugee found that he found against the appellant whichever test fell to be applied. Turning to the second point I was going to cover, which is main purpose. In many of the unallowable purpose tests, there's a reference to tax avoidance being a main purpose or one of the main purposes. The first point that I'd like to make about this concerns the commerciality of the transaction. The examples of section 74AZ of the ITA 2007 and 16A of the TCGA, which I've just mentioned, do not contain a separate defence that the transaction was a bona fide commercial transaction. In those circumstances, it's not sufficient, in order to avoid the application of the sections, for the taxpayer to show that there was a genuine commercial reason for entering the arrangements. Because even if the taxpayer can demonstrate that there was a genuine commercial reason, and that it was a main reason for the transaction or arrangements, the test contemplates there being more than one main reason. So you still have to ask whether there was also a main purpose of avoiding tax. This point is neatly illustrated by the quote from Lord Justice Rymer in Lloyd's TSB Equipment. Essentially, obtaining a relief or avoiding tax can still be a main purpose, even if not the main purpose, and even if every transaction that was involved had a commercial purpose. The Court of Appeal found that the first-tier tribunal had erred in focusing too much on the genuine commercial purpose, and for that reason, failing to give proper scrutiny to the importance of obtaining the capital allowances. That is also consistent with the upper tribunal's finding of 7 individuals, contrary to the submissions advanced by the taxpayer, that someone could be engaged in the trade with a view to profit, but nevertheless have a main purpose of avoiding tax. However, the fact that there has been a tax advantage obtained does not necessarily mean that it was a purpose of the arrangements to obtain it. And neither does the taxpayer's knowledge of the existence of a tax advantage, and neither does having taken tax advice thereon. All of these points were made by the FTT in its decision in Fisher, and those principles were set out by the upper tribunal in its recent decision without demur. Now, the first point, that it's important to distinguish the effect from the object or purpose, is particularly well illustrated by the upper tribunal's decision in Fisher. Although strictly obiter on this point, because the upper tribunal found that the TOAA legislation was not intended to cover the situation for corporate transferor, it is a helpful decision in its analysis of the purpose test. It's clear from the relevant statutory provisions that should be up on your screen, but worth noting, that the 2 limbs of the motive defence under the TOAA legislation apply to different categories of purpose. The first limb can be relied upon where avoiding tax was not one of the purposes. So it's a test contemplating multiple purposes, and tax avoidance cannot be any of those purposes. The second limb requires that the transfer and any associated operations were bona fide commercial transactions and were not designed for the purpose of avoiding liability to taxation. And in that context, the purpose has been interpreted as meaning the single main purpose. In Fisher, the transfer of the business from the UK to Gibraltar had the effect of avoiding liability to pay UK betting duty, and the defence under the first limb failed, because the FTT found that avoiding betting duty amounted to avoiding tax, and that was a purpose of the transfer. That part of the FTT's decision was effectively upheld, albeit obiter, by the upper tribunal. However, the upper tribunal found in favour of the taxpayer on the second limb of the motive defence, as the main purpose was to ensure the survival of the business, being a proper commercial purpose, and not tax avoidance. Effectively, in that case, the commercial imperative for the business to survive was so strong that it trumped the purpose of avoiding tax. Avoiding tax was found to be the means to the end of ensuring the business survived, but not the end in itself. A word of warning though, before relying too heavily on that decision. The upper tribunal said expressly that its analysis was based upon the very particular, indeed extreme facts of that case. Returning to purpose tests with a main purpose, if realistically the avoidance of tax was a purpose of the arrangements, it falls to be considered whether that purpose was an incidental purpose or a main purpose. And that's not an easy distinction to draw, especially in the abstract. But I like the descriptive language of Mr. Justice Lightman in SEMA Group Pension Scheme Trustees that was adopted more recently by the FTT in Hardy and Moxon, of asking whether the tax advantage was merely the icing on the cake. Mr. Justice Lightman also observed that the tax advantage can be a relevant factor in the decision to buy or sell, without necessarily constituting a main object. Considering this passage from SEMA, the FTT in Versteeg Limited and HMRC said that it is necessary to consider the significance of the tax advantage to the particular taxpayer, and that will involve an analysis of all the reasons that the taxpayer had for entering into the transaction. Then the third point I want to address, whose intention is it anyway? We've already seen that when the transaction concerns a company and the test is subjective, it's the intention of those in control of the company that matters. But what about the position where the company taxpayer forms part of a group? Is it right for HMRC to seek to fix the taxpayer company with the supposed purpose of the group as a whole, or that of the parent company? Oxford Instruments concerned the application of Section 441 of the CTA 2009 on an appeal by a UK resident subsidiary of the Oxford Instruments Group with a US resident immediate parent company. As will often be the case, the directors of the subsidiary were also directors or managers of other companies within the group. The tower structure, which was implemented, had been suggested by Deloitte in a paper unfortunately headed Oxford Instruments Tax Efficient Financing Structure, and was approved by the board at group level. Section 442 of the Act provides the meaning of unallowable purpose for the purpose of Section 441. Essentially, where there was a tax avoidance purpose, Section 442 requires consideration of whether that purpose was the main or one of the main purposes of the company in being a party to the loan or entering into the related transaction, as the case may be. So the test looks expressly at the purpose of the company for doing something, being a party to the loan relationship or entering into the related transactions. And it was agreed, therefore, in the FTT that the test was subjective, based on Bremner. The FTT was clear that in those circumstances, it was looking at the intentions of the board of the relevant taxpayer. Those intentions were not to be confused with the intentions of the board of its parent company, or with the intentions of the group as a whole. And the FTT also said that nor are the intentions of the board of the taxpayer company to be equated with the intentions of the advisor, which was in this case Deloitte. And those points must be correct, so that they would run counter to any general attempts by HMRC to attribute to a subsidiary company the intention of the overall group. However, the FTT did make the observation that matters could be different if the evidence pointed to the directors of the subsidiary being mere puppets that were simply acceding to the wishes of the parent company, or which had ceded effective control to the advisors in order that they could make the relevant decisions. And evidence of what the board or the taxpayer were told by the advisors and how the board reacted to that advice will obviously be relevant evidence to support or undermine the stated purpose given by the witnesses. The final point I just want to make on whose intention matters is derived from the obiter comments of the upper tribunal in Fisher. As stated earlier, the upper tribunal decided that the TOAA code did not apply to a corporate transfer law, but it went on to address the motive defence in any event, in case the FTT was correct that the 3 members of the Fisher family were quasi-transferors. There you have 3 different people who may have different purposes in making the transfer, or none. The FTT resolved that issue by observing that the statute requires consideration of the purpose of the transfer, not the purpose of the individual effecting the transfer. Ordinarily, where you have one transferor, the purpose of the transfer and the purpose of the transferor will be one and the same. The FTT said that where there are a number of transferors, determining the purpose of the transfer requires consideration of the purpose of each transferor before seeking a single consolidated purpose. The upper tribunal did not fault the FTT's attempt to apply the legislation in that way, although it had, of course, found the legislation did not apply to such a situation. Okay, so that is the end of my section, and I'm now going to hand over to Anna.
Thank you, Chris. And I'm going to share my screen. I have a few slides. Okay. So yes, as Chris said, I'm going to look at some of the evidential considerations when litigating cases where unallowable purposes are alleged, using some of the most recent case law to highlight how this is actually playing out in practice. So as you can see on the slide, I'll be looking first at the burden of proof, before turning to the documentary evidence, the question of witness evidence, and then some of the factors which are likely to be weighed by a tribunal or a higher court in a purpose case. So if we start then with the burden of proof, whilst there has been some debate in the case law as to where the burden of proof lies, in our view, the usual burden in a tax appeal applies, such that with HMRC having issued a closure notice on the basis that the taxpayer had an unallowable purpose, it's going to be the appellant who bears the burden of showing that it did not have that purpose. In any event, where HMRC has grounds for saying in a statement of case that there was an unallowable purpose, the taxpayer has at the very least an evidential burden of leading evidence of what its purpose was. Now, turning to documentary evidence. In accordance with the Guestman principles, so called after the judgment of Mr. Justice Leggett in the case of the same name, whether you're looking at a subjective or an objective test, or from the perspective of an individual or corporate, the best and the most reliable basis upon which a tribunal can make factual findings or draw inferences is going to be from the documentary evidence and the known or probable facts. So when considering the purpose for which an individual or a corporate entity entered into, for example, a series of transactions, contemporaneous documentation is going to be critical. So clearly documents such as board minutes, resolutions, presentations from advisors are going to be important evidence of, say, directors' intentions at the time of entering into the scheme. So when evaluating the strengths of an appellant's case and preparing it for litigation, it's vitally important that advisors get thoroughly into the documents and are realistic from the outset as to what inferences the tribunal is likely to draw and how we can best use witness evidence to explain it and set it in its proper context. So then turning to witness evidence, there's 3 particular aspects that I want to look at. The first one is, where do you pitch your case? Very often one sees witness statements and hears oral evidence from appellants, which puts the case too high. This obviously runs the risk of undermining the witness's credibility and therefore your case. So for example, one might see witnesses trying to argue that they entered into a scheme to secure a positive return on investment, when in reality it's clear that no rational investor would enter into the scheme because the economics of the scheme, after you've taken into account the fees they've paid and the potential return from any positive outcome, simply make it uncommercial. So it only makes sense once the potential loss is taken into account. And the very recent FTT decision of Sherrington and HMRC is a really good example of this. And so it's therefore much better to take a realistic view of the facts and the underlying evidence and seek to explain it, rather than simply make assertions which can't reasonably be supported by the facts. So second, cross-examination. What happens if your witness isn't challenged on their evidence as to purpose? This happened in the travel document case. There was evidence before the FTT from a Mr. Turner of the appellant as to the purpose for which TDS held its LGI shares. and they were seeking to distinguish that from TDS's reasons for proceeding with the transactions. Now, it wasn't directly challenged in cross-examination by the revenue. On that basis, it was argued for the appellant that it was not open for HMRC to contend or for the FTT to find that TDS had held the LGI shares for an unallowable purpose. The Court of Appeal emphasised the principle that yes, the witness's evidence should be challenged in cross-examination if the court is to be asked to disbelieve him. That's plainly very important. They agreed that in cases in which HMRC wishes to contend that a company had a tax avoidance motivation, in the face of evidence along the lines of that given by Mr. Turner, it will always be wise and most commonly be vital to raise the issue in terms with the witness. However, in the circumstances of that case, they did not find that the absence of such a challenge precluded a finding of unallowable purpose. Rather, there was a strong case based on inference from the circumstances in which the transaction took place and from the way in which the transaction was structured for saying that at least one of the purposes of the transaction was to avoid tax. It was not necessary in that case for the FTT to disbelieve Mr. Turner to decide that TDS had an unallowable purpose for holding its shares in LGI. And in the recent case of Davies and others and HMRC, the upper tribunal applied this approach from TDS in addressing a similar argument run by the taxpayer. And so then finally on witness evidence, adverse inferences. So should your potential witness even give evidence at all? We've already looked at how important it is to set the documentary evidence in context, but if the documentary evidence is problematic for you, it might be tempting not to expose a witness to cross-examination at all. However, the risk of not giving evidence probably outweighs that risk. A submission that the FTT should draw adverse inferences from a failure to call a witness in accordance with the Court of Appeal guidance in Wisniewski and Central Manchester Health Authority, which has been applied in the tax context in the case of HMRC and Sinico, it appears to be an increasingly common tactic of HMRC. Of course, the tribunal's job is to apply the relevant legislation to a realistic view of the facts, which in a purpose case will include the appellant's reasons for entering into the arrangements or transactions in question. And so by choosing not to give evidence, the tribunal may properly draw an inference that HMRC's case is strengthened in that regard. For if they had evidence to give, which would support their argument on purpose, the unavoidable question is going to be, why are they not giving evidence? So it's important, therefore, to lead witness evidence where possible, whilst, of course, giving careful thought to who is best placed to set out your case. For example, if there's a choice of directors, is it better to call the one who is most closely involved in receiving the relevant tax advice or least involved? So finally, then, I want to move on to look at some of the factors that a tribunal may consider when evaluating the evidence in purpose tests. Now, there is no statutory or mechanistic checklist of factors, and those that appeal to a tribunal will, as in any evaluative judgment, depend on the facts of the case. But here are some of the factors that we see commonly considered, and we can start with consistency. So this is one of the core Guessman principles, and it provides three main tests which give a useful pointer as to where the truth lies, although their relative importance will vary from case to case. And they are the consistency of the witness's evidence with what's agreed or shown by the other evidence to have occurred, the internal consistency of the witness evidence, and the consistency with what the witness has said on other occasions. And a good example of this is in the 2020 FTT decision in Alum and HMRC. In that case, the tribunal found in the taxpayer's favour on unallowable purpose, in part because the witness's evidence complied with these requirements. The appellant was successful in convincing the tribunal that his purpose was not one of avoiding tax. He had a personal reason and a commercial reason for structuring the relevant transactions as he had, but this was not a tax reason. In essence, Mr. Allen was looking for a way to build a retirement fund, and then in turn, the relevant transactions were structured so as to provide that for him. And the tribunal found that Mr. Allen gave clear reasons for the transfer in question, that he was consistent in those reasons, importantly at all stages, and that those reasons were supported by documentary evidence, stretching back some time before the transfer was conceived. So secondly, whether an alternative transaction existed. In some cases, the fact that an alternative transaction existed and was perhaps considered but rejected by an appellant may be a factor in deciding whether or not an inference can be drawn that the obtaining of a tax advantage was a main purpose. There are a number of different ways in which this can play out, but here are a couple of examples. So in Oxford Instruments, a case that Chris mentioned earlier, the tribunal found it was clear from the documents and from the testimony of the witness that avoiding or minimising additional net taxable income in the UK was a main purpose of the scheme. And in that case, the very fact that the two alternative structures on the table both involved avoiding or minimising net taxable income in the UK only strengthened that inference. In TDS, LGI had admitted it had an unallowable purpose for being party to the loans with TDS, but it disputed the FTT's decision that it was just and reasonable to attribute the totality of the debits in question to the unallowable purpose. They argued that they should be attributed to the unallowable purpose only, and if only to the extent that they would not have been incurred but for the tax planning. However, where their case fell down, evidentially, was that LGI had not supplied any particulars of what loans would have been made to it or what rates had it not entered into the avoidance scheme. And the Court of Appeal held it was just not enough for Mr. Turner's witness statement to make the argument and then not to back it up with any detail, and went on to note that during his cross-examination, there was still a dearth of specifics. So this goes to illustrate the importance of not just arguing your alternative case, but particularising that case and supporting it with documentary evidence. Thirdly, what you do with an asset or its benefits to you can be evidence of purpose. So in the case of FIDEX and HMRC, the upper tribunal stated, what you do with an asset may be evidence of your purpose in holding it, but it need not be determinative of that purpose. The benefits you hope to derive as a result of holding an asset may also evidence your purpose in holding it. And so in line with that, in TDS, the Court of Appeal held it was the company's subjective purpose that mattered. And when determining what that was, it could be relevant to look at what use was made of the shares it held. So earlier we saw how Mr. Allen's ability to point to evidence supporting his long-held personal intentions to build his pension fund was highly relevant to the question of purpose. Here we can see that what an individual or a company does after the relevant transaction can shine a light on what the purpose was in entering into it. And it's therefore essential to consider not only the gestation of a transaction, but what follows. Fourth, the relative size of the tax advantage. So the size of the tax advantage as compared to the wider commercial advantage to the transaction can also be a really important factor to weigh. In TDS, the Court of Appeal noted that had the tax advantage been small, there might have been scope for an argument as to whether an intention to use the shares to achieve it implied that the obtaining of the advantage was now a main purpose. In fact, however, the hoped-for gain was large, both in absolute terms, being more than £70 million, and when taken relative to the apparent value of TDS, some £280 million. It was found, therefore, that the inescapable inference was that securing the advantage had become a main purpose of holding the shares. So then lastly, on factors, what evidence can support a finding that a tax advantage was just an icing on the cake? So Chris has already discussed this, and how one question that may arise in a purpose case is whether it was a main purpose or merely an incidental purpose, the icing on the cake. But how does it work in practice? So in the FTT case of Hardy and Moxon and HMRC, the tribunal considered the weight attached to tax considerations in the underlying documentary evidence. They noted far more attention was given to tax considerations, for example, going to specialist tax counsel, emails referencing underlying tax concerns, than looking at the commercial prospects of the films they were investing in. And as regard the presentation materials to investors, these were telling in two respects. First, that the loss-making scenarios were more numerous and were depicted as profit-making from the investor's point of view. And second, that the materials appeared to be designed to appeal exclusively to investors who it was assumed would have income against which to set off losses. So it's important, therefore, to step back and look at what purpose the documentary evidence you have in your case is really speaking to. Where does that emphasis lie? What was the intention of the appellant in seeking advice? On what does most of the correspondence focus? Is it the tax advantage or is it the commercial rationale? And certainly when arguing a case for an appellant who's an individual rather than a corporate, you may well have less documentary evidence supporting a preconceived scheme, with perhaps just cursory advice from a high street IFA. And that's clearly going to make arguing that the background facts don't support an emphasis on the tax advantage easier than it will if you have a bundle full of presentations and materials for a heavily marketed scheme. So thank you. I think that's all we have time for on the evidential considerations in purpose. And back to Chris.
Thank you, Anna. Thank you very much. So we've had one question, which Don has had hopefully the benefit of Felicity's written answer in the Q&A. So I hope that that deals with that. There was one other question that Constantine raised, which is, if when choosing between two ways to structure a bona fide commercial transaction, you choose the most tax efficient option, will you almost always have a main unallowable purpose? When does a purpose start amounting to a main purpose? None of the recent cases appear to have dealt with this point properly, perhaps because most of them concern actual tax avoidance arrangements. I think the best guidance that I could offer on that is to go back to the passage I referred to in Mr. Justice Lightman and SEMA that Anna's just picked up there, the icing on the cake passage, because what is clear from that, if I just read out a slightly longer section from it, he said this: obviously, if the tax advantage is mere icing on the cake, it will not constitute a main object, nor will it necessarily do so merely because it is a feature of the transaction or a relevant factor in the decision to buy or sell. The statutory criterion is that the tax advantage shall be more than relevant, or indeed an object. It must be a main object. The question whether it is so is a question of fact for the commissioners in every case. And then, as said earlier in Vestige, the FTT said that therefore it's important to look at all the different reasons that for the company to enter into the transaction in a particular way, and consider how important tax was in the context of those reasons. So it will come down to a matter of fact in every case, but the one crumb of comfort I would offer to Constantine is that just because tax was a factor in a decision about, for example, whether to buy or sell or how to structure it, it doesn't necessarily mean that it will be a main purpose. It may mean that it is a purpose, but there is a distinction, as we've sought to draw out, between incidental purposes and main purposes. And if you can establish on the evidence that it was merely an incidental purpose, then you shouldn't be caught by the relevant provision. So I hope that addresses that question. And we're just about up on time. Unless there's anything further, I think we'll leave it there. Obviously, if people want to carry on using the chat function to discuss in a sort of any questions, any answers, interactive session afterwards, feel free. But otherwise, we'll call an end to the live webinar. As I say, thank you very much for attending again. And next week, the webinars return to the normal Friday slot, and we're going to have Aparna Nathan and Marika Lemos speaking about partnerships and inquiries, considering in particular their upper tribunal decision in Reed and Emlyn, and the Court of Appeal's judgment in the JR claim of Amrolia, in which I was led by Tim. So very much hope that you can tune in anyway next week, even if you can't see. Thank you very much.